Is now around the world. Lord Dwyer Schlecke, very special guest,
One that we never see,
as promised.
right?
Free legal advice
I hope
today.
people have their questions ready and are going to call. And what are they going to call? 787-3397.
Very good.
And they can't email. I don't bring a computer like Mark.
No, Mark's on assignment.
He's on assignment. He's actually helping a friend. And I don't have my phone with me, so you can't text me questions either.
No, if you have a question
You're going to have to do it the
For our-
old-fashioned way.
for our esteemed attorney,
You're going to have to call.
787-3397.
Okay.
Do you have a question?
Oh, you know what? I want to You're so funny.
Yeah, Laura, do you have a question?
So on Tuesday, I went to Lansing. Wednesday, Thursday, Tuesday I went to Lansing and testified in front of the Senate Financing Committee.
You did?
Yeah, Financing Committee. Because
Did you have to put your hand on the Bible?
No, it
No?
was actually like a minute. It's, it sounds impressive, but
Okay.
anyhow, when I did my research for that, the average sale price of a foreclosure right now is $42,000. No, I'm sorry, $46,000. The average sale price of a short sale in Jackson County is $76,800. And the average sale price of a normal person, no one that's under distress, is $113,100.
Okay.
So I thought that was good news.
Yeah.
I think we're seeing a turnaround. Fewer foreclosures.
So those are higher than you might have anticipated.
Well, I didn't. I only compared the previous foreclosure prices. I didn't have time to do previous short sales. We haven't tracked that long, so.
Why don't you let everybody know why it is you were testifying before the Finance Committee up in Lansing? Because that's fairly significant. That was with respect to the statute that's about to expire at the end of this month.
Right, and it passed. They're keeping the 90-day.
Well, this was a House committee, wasn't it, or was it Senate committee?
Senate.
All right, so it still has to go to the House, then it has to be signed by the governor, but the proposal was not to extend the state statute.
No, to extend it.
It was to extend the statute, which is about to expire, which allows, or requires rather, a mortgage lender, if they're going to use foreclosure by advertisement, to send with the notice of default a notice that the borrower has the right to a housing counselor and to insist that the lender engage in a negotiation for loan modification with that housing counselor and with the borrower, and if they fail to do so, then they must do a judicial foreclosure. And so it extends the period of it extends the period that a borrower has in which to salvage their property by 90 days. And the banking industry was trying to get the period of redemption reduced by a comparable 90 days so that the borrower would have less time to be able to salvage the property. So it was a very, very important hearing that you attended on Tuesday.
And they kept the 6-month redemption period in place,
Right.
which is good, for another year. So
it's
we'll
hard-
be
it's-
dealing with it for another year.
Right, it's good for
Or in and out.
borrowers, for people who own homes where they're underwater or they're having problems, they're in distress. It was a good move by the Senate Finance Committee. Again, let's hope that the law does get extended. It's still got to go to the House and then to the governor, but let's hope that it happens.
So, which segues into a question I have. Does foreclosure wipe out all liens?
It wipes out all subordinate liens.
What do you mean by that?
Well, let me give you, I've got several cases going on right now in which we've got junior lien claimants. We've got a case going over on the east side of the state, very, very large residential property. It's underwater with respect to the first mortgage. There are 2 judgment liens on the property. Both of those judgment liens get wiped out by the foreclosure. They'll be gone. In fact, there's a state statute that says if the borrower can show that in fact there's no equity in that property, those judgment liens are gone anyway, irrespective of the foreclosure of the first mortgage. I don't mean to get complicated here. Essentially, the first mortgage has priority over other liens. If there's a home equity loan on it, for example, that home equity loan will get wiped out. If there's an IRS tax lien, A lot of people think that the IRS tax liens have this super priority. They don't. They stand in line with every other lien claimant, so that the first mortgage that's on the property, when that mortgage was recorded with the County Register of Deeds, it was the only lien on the property. Let's suppose the borrower gets into income tax trouble, ends up with an IRS tax lien. The IRS has to go through the same process of recording its notice of tax lien with the Register of Deeds. If the first mortgage gets foreclosed, it wipes out the IRS tax lien. So the answer to your question is almost every lien will get wiped out. The only lien which has super priority, with very limited exception for certain environmental liens, super lien would be a tax lien, property tax lien. Property taxes always have priority, and the rationale is that everybody knows that when they buy property and own property in the state of Michigan, it's subject to the property taxes imposed by the local municipalities.
And when you say it wipes out the IRS lien, it doesn't mean the IRS problem goes away. It just means the lien on the house goes away.
You're exactly right. The lien goes away, but the obligation to the IRS does not go away. And that's true with any other junior lien claimant. If it's a home equity loan, the home equity lender has a lien on the property. The lien gets discharged or removed or is eliminated by virtue of foreclosure, but the debt still remains.
So in order to get rid of that debt, they would probably have to file bankruptcy?
Yeah, I'm not a bankruptcy lawyer, but that's the route that people end up doing, is they file bankruptcy in order to eliminate the obligation by virtue of whether it's a judgment, whether it's a junior lien, etc.
But bankruptcy doesn't take away IRS commitments, does it?
Yeah, sure.
Does
It
it?
can, except for certain withholding doesn't go away. Any fraud claims, if the basis for the tax claim is fraud, then that doesn't go away. There's certain claims that do not go away. Student loans don't go away in bankruptcy. Again, I'm not a bankruptcy expert, so I'm just giving you sort of the general knowledge that a real estate lawyer has of bankruptcy, which maybe isn't worth all that much. Remember, free legal advice is worth exactly what you pay for it.
Right. And if anyone out there has a question for Bill, call 787-3397. I have another one. How about if I'm a tenant and my landlord's in foreclosure? What happens to my security deposit that I gave my landlord?
All right. First of all, the security deposit is held by the landlord under the Security Deposit Act, Landlord-Tenant Relationship Act, and that's essentially your property. However, if the landlord has not kept that security deposit in a separate account or in an account, hasn't maintained it, that's a violation of the act. However, if that money is gone, the tenant's got a money claim against the landlord, which may not be worth a whole heck of a lot. It's like any other money damages claim. What we're finding, let me take this a little bit farther. You've got two separate categories of tenants. You have residential tenants where the property is their primary residence, and then you've got non-residential tenants, commercial tenants. And I go through this all the time with landlords, commercial landlords, and commercial tenants. Matter of fact, we just had a very large commercial lease die where I represented the tenant, and we were asking for what's known as an SNDA, a subordination and non-disturbance agreement, which says that the landlord will go to their lender and get an agreement from the lender that if the loan goes in default, in other words, if the landlord defaults on the mortgage, that the mortgage company, the lender, will still honor my client's lease if my client continues to make the payments under the lease. That's the non-disturbance. Subordination is we'll subordinate the lease to the mortgage, but mortgagee will honor the lease if the loan goes into default. And the reason we do that is because if my client comes in and invests, they actually planned on putting about $150,000 worth of improvements into the property. If the loan goes into default, the lender forecloses, and the lender decides not to honor the lease, my client will have lost $150,000 worth of improvements. So the SNDA has become a vital term in larger leases because we don't want to lose the value of those improvements. Residential leases are different because we have a state statute which says that where the landlord, the owner of the property, goes into foreclosure and the lender takes over, that the lender must honor the written lease, even if that lease has a 3-year term, 5-year term, whatever it may be. Landlord has, or the mortgagee has to honor that lease. And even if there isn't a written lease, the bank, the lender, has to give 90 days notice before they can evict the tenant who was on a month-to-month tenancy. Now, the only exception to that is where the bank takes over the property and sells it to a purchaser who is going to, him or herself, occupy the property as their principal residence. If the bank sells it to an investor who's not going to occupy it, then the investor still has to meet those obligations of honoring the lease and minimum 90-day notice if there is no lease. So we have taken some steps to protect tenants of residential properties in this state.
So if a bank takes over the house, I'm sure a tenant always has 30-day notice requirement, correct? Or can they evict a tenant? Let's say the bank forecloses, puts it right on the market, and I'm gonna buy it as my principal residence, and I can close it within a week, cash. Are you telling me that the tenant doesn't have any, will the tenant have to get out within that week period?
I don't think the statute addresses that particular circumstance, and absent that statute, the mortgage has priority over the lease. So the lender comes in, takes over the property, there is in essence no lease. They would still have to go through eviction proceedings in district court, what are called summary proceedings, to recover possession of real estate. That would take them that month in order to accomplish that, but there's no requirement of which I am aware. If the person now is buying for their own principal residence, that they'd have to wait for 30 days.
So they would be out.
Double check. I want to double check the statute. You know, she's asking me a question out of the blue. She's supposed to tell me these things in advance so that I can look them up. It's absent the statute. Clearly, there would be no right of the tenant to stay. The lender would come in. There's no 30-day notice requirement, and they would simply start their summary proceedings. Now, having said that, let me also say that many lenders right now, where they take over the property, they will actually negotiate with the current tenant to stay in the property because they would prefer that the tenant remain there. If it's a good tenant, take care of the property, then they don't end up with just a vacant property for a number of months. So that's something to think about. If you are a tenant in a property where the landlord has been foreclosed on and the bank has taken over, don't give up. Talk to usually the bank. It's what's known as an REO property, real estate owned property. The REO property is turned over to a local realtor. Talk to the realtor. See if the realtor will contact the lender and negotiate. It might just be a month-to-month lease, but the renter will at least get some relief.
And just a heads up, if you're buying a piece of property and you intend to occupy it or rent it out, you better check with the governmental authority to make sure there's no condemnation or violations, code violations that need to be repaired prior to occupancy.
All depends on the municipality in which you reside. If you're going to be a landlord, you need to get a certificate of occupancy in order to be able to rent that property out. What's Jackson have now? Inspections every 2 years or 3 years?
2.
The statute was changed to allow it every 3 years, maybe even 4 years if the municipality wants to. But they inspect the property, make sure that it's up to code. If it's not, state law actually provides that in order for a landlord to be able to enforce a claim for rent, the property must be habitable. The property must be in conformity with all local building codes, and if a certificate of occupancy is required, they must have a current and valid certificate of occupancy. So landlords have incentive to make certain that their properties are kept up to code. And so when that buyer's coming in and buying an REO property, they have to be very careful because the bank is selling that property strictly as is. The buyer will be signing all kinds of disclaimers and releases and indemnities so that the buyer wants to make certain the property is in good enough shape to be able to rent, or that they know what the costs are going to be.
Do I have those same concerns if I'm going to live in it myself? I would assume if the city has put violations on that property. Let's say it was a rental unit. Let's say it wasn't even a foreclosure. It was just a rental unit owned by someone, and then I come in and buy it as my primary residence. Do I still have to check for violations at the city
Yeah, you're going to
level?
want to check for the violations to make certain that the property is in conformity with the codes. Now remember that the codes may differ with respect to rental properties and where I occupy it myself, what needs to be done, what the cost of doing it may be. But if I'm a purchaser of that REO property, I'm going to want to have an inspection done so I know exactly what I have to do in order to meet whatever code requirements are, particularly safety and hazard requirements. And then also what's going to require just for me to move in to be able to occupy it in the condition that I want it to be in, or at least I know from the inspection what the cost is gonna be to bring it to the condition I want it to
And
be in.
unless you check, you're not gonna know because those items aren't gonna show up on a title search.
They don't show up on a title search at all. That has nothing to do with a title search.
So
And
you
then, let me also tell you, in some communities, there are what are known as point of sale requirements. City of Detroit, for example, you have to have a housing inspection in order to close the sale. Jackson does not have a point of sale requirement yet. Municipalities are starting to move toward that, but we don't have point of sale yet.
So when buying real estate, what should I look for when I'm buying it as is? This is such a great segue.
Good segue.
Yeah, how much time you get? Is this an hour-long program or an hour and a half?
It's about
3 hours,
we're
4
down to
more minutes?
About 4 minutes.
Yeah. Okay, look, the most important thing you can do is have an inspection by a qualified, independent inspector who will certify the inspection to you. You absolutely do not rely upon an inspection which was done by the seller. Some sellers think that by having an inspection done pre-sale or pre-listing, that what they're going to do is they're going to save time with respect to the deal so the buyer doesn't have to do an inspection. Buyer doesn't want that at all. Buyer wants their own inspection certified to the buyer. They need to check the home inspection contract to make sure it doesn't have a limitation of liability clause in it that limits the liability of the inspector to the amount that the purchaser paid for that inspection, because those liability limitations are enforceable. Okay? But inspection is absolutely critical. And then obviously title work is critical. Knowing that getting copies of the documents referenced in the title commitment are essential. Having a good realtor is essential. Yeah, that's what you look for.
All right. I keep having these questions pop up and then I forget them.
Look, you know
I gotta
that,
eat whatever it takes to
you
remember.
know that I teach the 6-hour annual continuing education course to real estate licensees. We
But
spend
anybody could take that class.
Yeah, but we spend 6 hours talking about this kind of stuff, and you give me just a few minutes to try and address it. There are so many things that people should be looking for, that the realtor is looking for on behalf of a buyer, to make certain that the buyer gets protection with respect to the condition of the property, the condition of title, the transfer of title, all that sort of stuff.
And who needs to sign the deed and where do they live and
Bill, if the seller does an inspection, should you be buyer beware there?
You should always be buyer beware, because the state of the law in Michigan is that there is no duty of disclosure on the part of a real estate seller other than to disclose hazardous conditions, to disclose any latent or hidden defects that the seller is aware of that the seller concealed. Or third, if the seller makes an affirmative or a positive statement about the condition of the property and that statement is false, that's fraud. But those are the only 3 times that the seller has liability. Our law in Michigan says that it's really buyer beware, whether it's residential or non-residential. An inspection by a qualified, independent inspector is the best thing you can do.
In that case, what scenario does the buyer get burned in?
Oh my God, roof leaks, basement leaks, mold, underground storage tanks. They can. There's so
Depends on where it is.
I've seen absolutely every kind of defect in real estate deals where the buyer comes in after the fact and says, "Look, I'm having a problem here. What can I do about it?"
Now, it seems like the seller would know that they have mold, but that's not always the case, right?
No,
That could be hidden.
not always the case. I wouldn't say that the seller always knows there's mold, although mold requires moisture, and so usually you find out that they've had a water issue at some time, whether from the foundation or from the roof.
or how about a leaky pipe in the walls?
Could be anything. Could be anything. But it's moisture that is I need air, I need moisture, I need food. The cellulose in drywall and wood products,
Sounds
that's
like a
the
person to
food.
me.
I've got air, so now it's the introduction of moisture. So the way to prevent mold is to prevent the introduction of moisture into the house. Once it gets in there, now it becomes a problem.
Well, we are running out of time, so thank you for your brilliant insight.
I live to
There's
serve.
no wonder I'm married to you.
I live to serve, Laura.
Price reductions, 1101 Pringle is 46,120. 13317 Bunker Hill Road, which is an awesome log home on 12 or 13 acres, is $316,840. 386 Gillet's Lake Road, which is right across from Gillet's Lake, is $47,905. And then a nice city home at nice big city home at 409 Garfield is down to $23,575.
Those are all on your website.
Those are all on our website, thinkingrealestate.com, and you can call us at 780-3800, or you can email me at Laura at thinkingrealestate.com.